All right, the court is calling 2021 CR 4788, State of Texas versus James Stagmire. Could I have parties approach and announce for the record for the state,
Michelle Hayden for the state.
for the defense?
John Coons for Mr. Stagmire.
All
Just make sure you speak up.
right, and are you Mr. Stagmire?
Yes, I am.
All right, I'm showing defense what is entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. This says no application, but I see that there's an application for deferred adjudication.
It should say that the state makes no recommendation or
Okay.
but basically we're silent. I apologize if there was an error.
Oh, no problem. All right, Mr. Stagmire, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on count 3 of the indictment. It's the one of the indecency with child by contact allegations, and we're waiving the remaining allegations.
We obviously have no objection to that.
All right, Mr. Stagmire, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
You understand that the state is proceeding on indecency with the child by contact. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this cause?
Yes.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Judge, he has, and if I could put on the record about his mental competency and status,
Yes.
when I was appointed to represent him, I was informed by his family.
Okay, excuse me, everybody in the box, you need to whisper. If you can't whisper, you need to stop talking until we finish on the record. Defense?
Oh, do you need me to start over? Sure. When I first got appointed on this case, Judge, Mr. Stagmire's family informed me that he had a long history with the VA dealing with his Parkinson's and that he had been diagnosed with dementia some 20 years ago in the early 2000s. I was able to get, with the family's help, a huge box of the equivalent of probably 4 or 5 bankers boxes full of medical records. I submitted them to Dr. Scott after he had evaluated Mr. Stagmire the first time. Dr. Scott, in his first evaluation, had determined that he was competent. He did not see any signs of dementia. I provided the documentation, additional documentation to Dr. Scott. Once I received it, he reviewed that as well and said it did not change his opinion. I have had no issues with regard to my client understanding what's going on in the courtroom, the plea bargain, the case, the defenses, anything like that. But I just wanted to put on the record that these steps have been taken to address any potential competency issues on this case.
All right, so do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Mr. Stagmire, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 3. They're asking that your punishment be assessed at a cap of 6 years in prison. There's a $1,500 fine. State will remain silent on your application. There's to be Chapter 62 registration and no complaint no contact with the complainant and any other minor children. Did you understand that to be the agreement?
Yes, ma'am.
Defense,
Yes.
state?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged in count 3, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
State offers State's Exhibit 1 and its attachments into evidence.
We've reviewed them and have no objections, Your Honor.
Mr. Stagmire, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We're going to come back on October 24th, and there'll be a PSI report done, and the court will make a decision on your application based upon that report and whatever evidence is presented to me. Is there expectation of witnesses?
Well, since we're silent, no, but there will be victim impact most likely.
Is there any need for any type of PAP evaluation?
Sure, yes. And maybe even a mental health evaluation.
All right, we can do MIC, but I do believe that even if people were to qualify Maya based upon the charges, they probably won't accept him.
Okay.
All right, so I'm going to want a PSI report on Mr. Stagmire. We're going to come back on October 24th, and on that date, I'll let you know my ruling on your application. Is there anything else from either side?
No, Your Honor.
No, Judge, thank you.